by having senior advisors to the president be immune from compelled congressional testimony, because once someone is compelled to sit in the witness seat and start answering questions, it's very hard for them to protect that privilege, to make sure that they don't start revealing something that was discussed. So for a small circle of those close to the president, for the past 40 to 50 years, administrations of both parties have insisted on this principle. Now, the other night, the House managers, when we were here very late last week, they suggested that executive privilege was a distraction, and Manager Nadler called it nonsense. Not at all. It is a principle recognized by the Supreme Court, a constitutional principle grounded in the separation of powers. They also asserted that this immunity has been rejected by every court that has addressed it, as if to make it seem that lots of courts have addressed this. They've all said that this theory just doesn't fly. That's not accurate. That's not true. In fact, in most instances, once the president asserts immunity for a senior advisor, the accommodations process between the executive branch and the legislature begins, and there's usually some compromise to allow perhaps some testimony not in an open hearing, but in a closed hearing or in a deposition, perhaps to provide some other information instead of live testimony. There's a compromise. But the only two times it's been litigated, district courts, it is true, rejected the immunity. One was in a case involving former counsel to President George W. Bush, Harriet Miers. The district court rejected the immunity, but immediately on appeal, the Court of Appeals for the D.C. Circuit stayed that decision. And that decision means to stay that district court decision, that the appellate court thought there was a likelihood of success on appeal, that the executive branch might succeed, or at a minimum, that the issue of immunity presented questions going to the merits so serious, substantial, difficult, and doubtful as to make them a fair ground for litigation. So the first decision was stayed. The second district court decision is still being litigated right now. It's the McGahn case that the House has brought, trying to get testimony from former counsel to President Trump, Donald McGahn. And that case was just argued in the D.C. Circuit on January 3rd. So there is no established law suggesting that this immunity somehow has been rejected by the courts. It's still being litigated right now. And it is an immunity that is a standard principle asserted by every administration of both parties for the past 40 years. Asserting that principle can't be treated as obstruction of Congress. The third action that the president took, that the administration took, related to the fact that House Democrats' subpoenas tried to shut out executive branch counsel, agency counsel, from the depositions of executive branch employees. Now, the Office of Legal Counsel concluded that congressional committees may not bar agency counsel from assisting an executive branch witness without contravening the legitimate prerogatives of the executive branch, and that attempting to enforce a subpoena while barring agency counsel, quote, would be unconstitutional, unquote. The president relied on that legal advice here. As Judge Starr pointed out, the president was consulting with the Department of Justice, receiving advice from the very respected Office of Legal Counsel, and following that advice about the constitutional prerogatives of his office and the constitutional prerogatives of the executive branch. Again, administrations of both political parties have recognized the important role that agency counsel plays. In the Obama administration, the Office of Legal Counsel stated that exclusion of agency counsel, quote, could potentially undermine the president's constitutional authority to consider and assert executive privilege where appropriate. So why is agency counsel important? As I tried to explain, the executive privilege of confidentiality for communications with the president, for internal deliberative communications of the executive branch, those are important legal rights. They're necessary for the proper functioning of the executive branch. And agency counsel is essential to protect those legal rights. When an individual employee goes in to testify, he or she might not know, probably would not know, where is the line for what's covered by executive privilege or deliberative process privilege? Not things that employees necessarily know. And their personal counsel, even if they're permitted to have their personal counsel with them, same thing. Most attorneys for employees don't know the finer points of executive branch confidentiality interests, of deliberative process privilege, and it's also not their job to protect those interests. They're the personal lawyer for the employee who's testifying, trying to protect that employee from potential legal consequences. We usually have lawyers to protect legal rights. So it makes sense when there is an important legal and constitutionally based right at stake, the executive privilege, that there should be a lawyer there to protect that right for the executive branch. And that's the principle that the Office of Legal Counsel endorsed. This also doesn't raise any insurmountable problems for congressional investigations or finding information. In fact, just as recently as April 2019, the House Committee on Oversight and Government Reform reached an accommodation with the Trump administration after the administration had declined to make someone available for a deposition because of the lack of agency counsel. And that issue was worked out, an accommodation was made, and there was some testimony provided in other circumstances. So it doesn't always result in the kind of escalation that was seen here straight to impeachment. The accommodation process can work things out. House Democrats have pointed to a House rule that excludes agency counsel, but of course a House rule cannot override a constitutional privilege. So those are the three principles that the Trump administration asserted. Now I'd like to turn to the claim that somehow this assertion of these principles created an impeachable offense. The idea that asserting defenses and immunities, legal defenses and immunities in response to subpoenas, acting on advice of the Department of Justice is an impeachable offense is absurd, and it is dangerous for our government. Let me explain why. House Democrats' obstruction theory is wrong first and foremost because in a government of laws, asserting privileges and rights to resist compulsion is not obstruction. It's a fundamental right. In Borden-Kircher versus Hayes, the Supreme Court explained to punish a person because he has done what the law plainly allows him to do is a due process violation of the most basic sort. And for an agent of the state to pursue a course of action whose objective is to penalize a person's reliance on his legal rights is patently unconstitutional. This is a principle that in the past, in the Clinton impeachment, was recognized across the board, that it would be improper to suggest that asserting rights is an impeachable offense. Harvard Law professor Lawrence Tribe said, quote, "The allegations that invoking privileges and otherwise in using the judicial system to shield information is an abuse of power that should lead to impeachment and removal from office is not only frivolous, but also dangerous." And Manager Nadler then said that the use of a legal privilege is not illegal or impeachable by itself, a legal privilege, executive privilege. And Minority Leader Schumer in the Clinton impeachment expressed the same view.
To suggest that any subject of an investigation, much less the president with obligations to the institution of the presidency, is abusing power and interfering with an investigation by making legitimate legal claims using due process and asserting constitutional rights is beyond serious consideration.
And that was exactly correct then, and it's exactly correct now. Now, more important than simply the principle that asserting rights can't be considered obstruction, when the rights the president is asserting are based on executive privilege, when they are constitutionally grounded principles that are essential for the separation of powers and protecting the institution of the office of the presidency, to call that obstruction is to turn the Constitution on its head. Defending the separation of powers cannot be deemed an impeachable offense without destroying the Constitution. Accepting that approach would do permanent damage to the separation of powers, and it would allow the House of Representatives to turn any disagreement with the executive over informational demands into a supposed basis for removing the president from office. It would effectively create for us the very parliamentary system that the framers sought to avoid. Because by making any demand for information and goading the executive to a refusal and treating that then as impeachable, the House would effectively be able to function with a no-confidence vote power. Now, that is not the framers' design. The legislative and executive branches frequently clash on questions of constitutional interpretation, including about congressional demands for information. These conflicts have happened since the founding. In 1796, George Washington, first president, resisted demands from Congress for information about the negotiation of the Jay Treaty. And there have been conflicts between the executive and the Congress in virtually every administration since then about congressional demands for information. The Founding Fathers expected the branches to have these conflicts. James Madison pointed out that the legislative, executive, and judicial departments must, in the exercise of their functions, be guided by the text of the Constitution according to its own interpretation of it, each according to its own interpretation of it. It was recognized that there would be friction. Similarly, in Federalist 51, Madison pointed out that the great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachment of the others. This is checks and balances, this friction, this clashing between the branches. It is not evidence of an impeachable offense. It's the separation of powers in its practical operation. It's part of the constitutional design. Now, the proper and historically accepted way that these disagreements have been resolved is through the constitutionally mandated accommodations process. Courts have explained that the branches are required to engage in an accommodations process to resolve disagreements where there's a clash over a demand for information. As the D.C. Circuit has explained, when Congress asks for information from the executive branch that triggers, quote, an implicit constitutional mandate to seek optimal accommodation of the needs of the conflicting branches, end quote. The goal is to accommodate the needs of both branches to reach a compromise. If that accommodation process fails, Congress has other tools at its disposal to address a disagreement. The House traditionally has proceeded to contempt, to a vote on a contempt resolution. In recent times, the House has taken the position that it may sue in the courts to determine the validity of its subpoenas and secure an injunction to enforce them. Now, the House managers have pointed out that the Trump administration, when it was sued in the McGahn case and other cases, has taken the view that those cases are not justiciable in Article III courts. That is correct. That is the view of the Trump administration. That was the view of the Obama administration. And so there is that resistance in the court cases to the jurisdiction of the courts to address those. But I think House managers are missing the point when they identify that position that the administration has taken. Because the House cannot claim that they have a mechanism for going to court. They're in court right now asserting that mechanism in the McGahn case. And then simultaneously claim that, well, they don't have to bother with that mechanism, they can jump straight to impeachment. Impeachment under the Constitution is the thermonuclear weapon of interbranch friction. And where there is something like a rifle or a bazooka at the House's disposal to address some friction with the executive branch, that is the next step. It is incrementalism in the Constitution, not jumping straight to impeachment, that is the solution. If the House could jump straight to impeachment, that would alter the relationship between the branches. It would suggest that the House could make itself superior over the executive, dangle the threat of impeachment over any demand for information made to the executive. That's contrary to the framers' plan. Madison explained that where the executive and the legislative branches come into conflict, this is in Federalist 49, he said, quote, "Neither of them, it is evident, can pretend to an exclusive or superior right of settling the boundaries between their respective powers," end quote. But that is exactly what the House managers have asserted in this case. They have said that the House becomes supreme, there's no need for them to go to court, the executive must be wrong, any resistance to their subpoena is obstruction. If you claim that our subpoena is invalid, we don't have to do anything to address that concern. We will just impeach you because resistance is obstruction of Congress. And the House committee even put it this way in their report, the Judiciary Committee. They said that the House itself, they effectively have said that the House is the judge of its own powers because what they said was, quote, "The Constitution gives the House the final word," end quote. That's on page 154 of the House Judiciary Committee report. And what that is essentially saying, they point to the fact that Article 1, Section 2 gives the House the sole power of impeachment. And they claim that because it's the sole power of impeachment, the courts have no role, the House is the final word, it's the judge of its own powers. But that's contrary to the constitutional design. There is no power that is unchecked in the Constitution. The sole power of impeachment given to the House simply means that that power is given solely to the House, not anywhere else. The Constitution does not say that the power of impeachment is the paramount power that makes all other constitutional rights and privileges and prerogatives of the other branches fall away. The framers recognized that there could be partisan impeachments. There could be impeachments for the wrong reasons. And they did not strip the executive branch of any of its means for protecting its own sphere of authority, its own prerogatives under the Constitution. Those principles of executive privilege, those immunities, still survive, even in the context of impeachment. The power of impeachment is not like the House can simply flip a switch and say, now we're in impeachment, and they have constitutional kryptonite that makes the powers of the executive eliminated. So when there are these conflicts, even in the context of an impeachment inquiry, the executive can continue to assert its privileges and prerogatives under the Constitution, and indeed it must, in order to protect the institutional interests of the office of the presidency and to preserve the proper balance between the branches under the Constitution. Professor Turley rightly pointed out that by claiming Congress can demand any testimony or documents and then impeach any president who dares to go to the courts, House Democrats were advancing a position that was, quote, entirely untenable and abusive of an impeachment, end quote. Other scholars agree. In the Clinton impeachment, Professor Susan Lowe Block testified that, quote, impeaching a president for invoking lawful privileges is a dangerous and ominous precedent, end quote. It would achieve exactly the result that Gouverneur Morris, one of the framers, warned against at the Constitutional Convention. He explained that, quote, when we make him, referring to the president, amenable to justice, however, we should take care to provide some mode that will not make him dependent on the legislature, end quote. That is exactly what this article of impeachment would do. It would make the president dependent on the legislature, because any demand for information made by Congress could be used as the threat of impeachment to enforce compliance by the executive. And the very theory that the House Democrats have asserted is that there can be no assertions of privileges, no constitutionally based prerogatives of the executive to stand in the way. If that theory were true, virtually every president could have been impeached. Virtually every president has asserted at one time or another these constitutional prerogatives. President Obama famously, in the Fast and Furious investigation, refused to turn over documents that led to his attorney general being held in contempt. But that didn't lead to impeachment. And there could be a long list. Professor Turley testified There'd be a very long list of presidents who would have to be distinguished if the principles being asserted now, in this case, were applied to all past presidents in history. Now, the House Democrats have given a few different justifications for this approach, but I would submit none can be reconciled with the Constitution. They say that if we cannot impeach the president for this obstruction, then the president is above the law. Not so. As I think I've pointed out, the president is staying within the law, asserting the law, relying on the legal advice from the Department of Justice to make his arguments based on long-recognized constitutional principles, and indeed is making the fundamental point with respect to the subpoenas that it is Congress that is not above the law. It's the House. The House has to follow the law as well, has to issue valid subpoenas. And if the law isn't followed, those subpoenas are null and void, and the executive doesn't have to comply with them. The House Democrats say that they shouldn't go to the courts because the courts have no role in impeachment. I think I've pointed out that the House Democrats can't say that they have just because of the provision of the sole power of impeachment, that it's the paramount power and that no other branch plays any role in providing a check on how that power is exercised. And in addition, the House Democrats have gone to court. In the McGahn case that they're litigating right now, they have asserted that that is part of the impeachment inquiry. The Trump administration has explained that it was not validly part of the impeachment inquiry, but that is the ground on which they are litigating that. They say that they have no time for the courts. I think what that really means is they have no time for the rule of law in the way that they're pursuing the inquiry. The other day, one of the House managers actually said on the floor of the Senate that they had to get moving. They couldn't wait for litigation because they had to impeach the president before the election. That's not a valid reason to not pursue litigation in the courts. And I think it's relevant to bear in mind, what sort of delay are we talking about? In the McGahn case that the House managers referred to a number of times, which they had pointed out they presented as being very long and drawn out, they issued a subpoena in April, but they did not file a lawsuit until August. By November 25th, they had a decision from the district court, and it was argued on appeal in the D.C. Circuit on January 3rd. For litigation, that's pretty fast, and it can go faster. In the Nixon case, during Watergate, the special prosecutor issued a subpoena on April 18th, 1974. On May 20th, so in less than a month, the district court denied a motion to quash the subpoena. On May 31st, the Supreme Court agreed to hear the case, granting cert before judgment in the Court of Appeals, and on July 24th, the Supreme Court issued a decision. That's lightning fast. So when there is urgency to the case, when there is a reason for it, there can be expedition in the courts, and a decision can be had in a timely manner. In the one case that actually arose from these impeachment proceedings, it was the House that derailed the case. This was the case involving Deputy National Security Advisor Charlie Kupperman, because when he received a subpoena, he went to court and asked the court for a declaratory judgment explaining what his obligations were. Should he take the directive from the president that he was immune and not go, or should he obey the subpoena? Now, in that case, he filed suit on October 25th. The court, within a few days, set an expedited briefing schedule, but the House withdrew the subpoena on November 5th, just 11 days later, in order to moot the case. So I think litigation is a viable avenue, along with the accommodation process as a first step. Then if the House believes that it can go to court and wants to litigate the jurisdiction and litigate the validity of its subpoenas, that's also available to them. But impeachment, as the first step, doesn't make any sense. And I should point out, in part, when the House managers say they didn't have time to litigate, they didn't have time to go to the courts, but they now come to this chamber and say, this chamber should issue some more subpoenas. This chamber should get some witnesses that we didn't bother to fight about. What do you think will happen then? That there won't be similar assertions of privilege and immunity? That there wouldn't be litigation about that? Again, this goes back to the point that I made. If you put your imprimatur on a process that was broken and say, yes, that was a great way to run things, this was a great package to bring here, and we'll clean up the mess and issue subpoenas and try to do all the work that wasn't done, then that becomes the new normal. And that doesn't make sense for this body. The proper way to have things handled is to have the House, if it wants to bring an impeachment here ready for trial, it has to do the investigation. The information it wants to get, if there's going to be resistance, that has to be resolved, and it has to be ready to proceed, not transfer the responsibility to this chamber to do the work that hasn't been done. They also assert that President Trump's assertion of these privileges is somehow different because it's unprecedented and it's categorical. Well, it's unprecedented perhaps in the sense that there was a broad statement that a lot of subpoenas wouldn't be complied with, but that's because it was unprecedented for the House to begin these proceedings without voting to authorize a committee to issue the subpoenas. That was the first unprecedented step. That's what had never happened before in history. So of course the response to that would be in some sense unprecedented. And the President simply pointed out that without that vote, there were no valid subpoenas. And there have also been categorical refusals in the past. President Truman, when the House Committee on Un-American Activities in 1948 issued subpoenas to his administration, issued a directive to the entire executive branch that any subpoena or demand or request for information, reports, or files of the nature described in those subpoenas shall be respectfully declined on the basis of this directive, and he referred all such inquiries to the Office of the President for such response as the President may determine to be in the public interest. And the Truman administration responded to none of them. A last point on the House Democrats' claim that the privileges simply disappear because this is the impeachment power of the House. They have referred a number of times to United States versus Nixon, the Supreme Court decision, suggesting that that somehow determines that when you're in an impeachment inquiry, executive privilege falls away. Well, that's not true. In fact, United States versus Nixon was not even actually addressing a congressional subpoena. It was a subpoena from the special prosecutor. And even in that context, the court did not say that executive privilege simply disappears. Instead, this court said, quote, "It is necessary to resolve these competing interests." They're the interest of the judicial branch in administering a criminal prosecution, a case where the evidence was needed. These competing interests in a manner that preserves the essential functions of each branch. And it even held out the possibility that in the field of foreign relations and national security, there might be something approaching an absolute executive privilege. And that's exactly the field that we're in this case, foreign relations and national security matters. Another thing that you've heard is that President Clinton voluntarily cooperated with the investigation that led to his impeachment, produced tens of thousands of documents. But that's not really accurate. That was only after long litigation again and again about assertions of privilege. He asserted numerous privileges. The House Judiciary Committee then explained, quote, "During the Lewinsky investigation, President Clinton abused his power through repeated frivolous assertions of executive privilege by at least 5 of his aides," end quote. Unlike the House in this case, independent counsel Starr first negotiated with the White House and then litigated those claims and got them resolved. Ultimately, the House managers argue that all of the problems with their obstruction theory should be brushed aside, and the President's assertions of immunities and defenses have to be treated as something nefarious, because as Mr. Nadler put it, only guilty people try to hide the evidence. That's what he said last Tuesday night. And Mr. Schiff similarly said in discussing the assertion of the executive branch's constitutional rights that, quote, the innocent do not act this way, end quote. Really? Is that the principle in the United States of America? That if you assert legal privileges or rights, that means you're guilty? That the innocent don't assert their rights? That the president can't defend the constitutional prerogatives of his office? That doesn't make any sense. At bottom, the second article of impeachment comes down to a dispute over a legal issue relating to constitutional limits on the ability of the House to compel information from the executive. No matter how House Democrats try to dress up their charges, a difference of legal opinion does not rise to the level of impeachment. Until now, the House has repeatedly rejected attempts to impeach presidents based on legal disputes over assertions of privilege. As Judge Starr pointed out, in the Clinton proceeding, the House Judiciary Committee concluded that the president had improperly exercised executive privilege, yet still concluded that it did not have the ability to second-guess the rationale behind the president or what was in his mind asserting executive privilege, and that it could not treat that as an impeachable offense. It rejected an article of impeachment based on Clinton's assertions of privilege. And as the House Democrats' own witness, Professor Gerhardt, has explained, in 1843, President Tyler similarly was investigated for potential impeachment. His attempts to protect and assert what he regarded as the prerogatives of his office, because he had resisted demands for information from Congress. Professor Gerhardt explained that Tyler's attempts to protect and assert what he regarded as the prerogatives of his office were a function of his constitutional and policy judgments, and they could not be used, the Congress determined, to impeach him. President Trump's resistance to congressional subpoenas was no less a function of his constitutional and policy judgments, and it provides no basis to impeach him. I'd like to close with a final thought. One of the greatest issues, and perhaps the greatest issue for your consideration in this case, is how the precedent set in this case will affect the future. The framers recognized that there would be partisan and illegitimate impeachments. Hamilton expressly warned in Federalist Number 65 about impeachments that reflected what he called, quote, the persecution of an intemperate or designing majority in the House of Representatives, end quote. That is exactly what this case presents. And Justice Story recognized that the Senate provided the proper tribunal for trying impeachments because it was believed by the framers to have a greater sense of obligation to the future, to future generations, not to be swayed by the passions of the moment. And one of the essential questions here is, will this chamber adopt a standard for impeachment, a diluted standard, that fundamentally disrupts, damages, alters the separation of powers in our constitutional structure of government? Because that is what both the first article, for reasons that Judge Starr and Professor Dershowitz have covered, and the second article, the obstruction charge, would do. And so I'll close just with a quotation from one of the Republican senators who crossed the aisle and voted against convicting President Andrew Johnson during his impeachment trial. It was Lyman Trumbull, who explained, I think, the great principle that applies here. He said, quote, once we set the example of impeaching a president for what, when the excitement of the hour shall have subsided, will be regarded as insufficient causes, no future president will be safe. And what then becomes of the checks and balances of the Constitution, so carefully devised and so vital to its perpetuity? They are all gone. Thank you, Mr. Chief Justice. I'll yield to Mr. Sekulow.
Mr. Chief Justice, members of the Senate, House managers. Mr. Philbin talked about the importance, just concluded on the importance of executive privilege. Professor Turley, who testified before the House, said we have 3 branches of government, not 2. If you impeach a president, if you make a high crime and misdemeanor out of going to court, it is an abuse of power. It's your abuse of power. With regard to executive privilege, it was Mr. Nadler who called it executive privilege and other nonsense. When Attorney General Holder refused to comply with subpoenas, President Obama invoked executive privilege, arguing, and I quote, compelled disclosure would be inconsistent with the separation of powers established in the Constitution. Executive power and other nonsense. Manager Schiff wrote that the White House assertion of executive privilege was backed by decades of precedent that has been recognized and has recognized the need for the president and his senior advisors to receive candid advice and information from their top aides. Executive privilege and other nonsense. The nonsense, we talked about this the other night, is to treat the separation of powers and constitutional privileges as if they're asbestos in the ceiling tiles. You can't touch them. That's not the way the Constitution is designed. We're going to now turn our attention to a separate topic. It's one that was been discussed a lot on the floor here and will be discussed now. Presenting for the President is the former Attorney General for the state of Florida, Pam Bondi. She is also a prosecutor, a career prosecutor. She's handled countless cases. She's going to discuss an issue that the House managers have put pretty much at the center of their case, and that's the issue of corruption in Ukraine, particularly with regard to a company known as Burisma. I yield my time, Mr. Chief Justice, to former Attorney General Pam Bondi.
Chief Justice. Senators. Members of the Senate. When the House managers gave you their presentation, when they submitted their brief, they repeatedly referenced Hunter Biden and Burisma. They spoke to you for over 21 hours, and they referenced Biden or Burisma over 400 times. And when they gave these presentations, they said there was nothing to see, it was a sham. This is fiction. In their trial memorandum, the House managers described this as baseless. Now, why did they say that? Why did they invoke Biden or Burisma over 400 times? The reason they needed to do that is because they are here saying that the president must be impeached and removed from office for raising a concern. And that's why we have to talk about this today. They say sham, they say baseless, because they say this because if it's okay for someone to say, hey, you know what? Maybe there's something here worth raising, then their case crumbles. Because they have to prove beyond a reasonable doubt that there is no basis to raise this concern. But that's not what public records show. Here are just a few of the public sources that flagged questions surrounding this very same issue. The United Kingdom Serious Fraud Office, Deputy Assistant Secretary of State George Kent, Hunter Biden's former business associate, an ABC White House reporter, Good Morning America, ABC, The Washington Post, The New York Times, Ukrainian law enforcement, and the Obama State Department itself. They all raised this issue. We would prefer not to be talking about this. We would prefer not to be discussing this. But the House managers have placed this squarely at issue, so we must address it. Let's look at the facts. In early 2014, Joe Biden, our Vice President of the United States, led the United States foreign policy in Ukraine with the goal of rooting out corruption. According to an annual study published by Transparency International, during this time, Ukraine was one of the most corrupt countries in the entire world. In Ukraine, there's a natural gas company called Burisma. Burisma has been owned by an oligarch named Mykola Zlochevsky. Here's what happened very shortly after Vice President Biden was made U.S. point man for Ukraine. His son, Hunter Biden, ends up on the board of Burisma, working for and paid by the oligarch Zlochevsky. In February 2014, in the wake of anti-corruption uprising by the people of Ukraine, Zlochevsky flees the country, flees Ukraine. Zlochevsky, the oligarch, is well known. George Kent, the very first witness that the Democrats called during their public hearings, testified Zlochevsky stood out for his self-dealings even among other oligarchs. House managers didn't tell you that. Ambassador Kurt Volkler explained that Burisma had a, quote, very bad reputation as a company for corruption and money laundering, end quote. House managers didn't tell you that. Burisma was so corrupt that George Kent said he intervened to prevent U.S. aid from co-sponsoring an event with Burisma. You know what this event was? It was a child's contest, and the prize was a camera. They were so bad, Burisma, that our country wouldn't even co-sponsor a children's event with Burisma. In March 2014, the United Kingdom Serious Fraud Office opens a money laundering investigation into the oligarch Zlochevsky and his company, Burisma. The very next month, April 2014, according to a public report, Hunter Biden quietly joins the board of Burisma. Remember, early 2014 was when Vice President Biden began leading Ukraine policy. Here's how Hunter Biden came to join Burisma's board in April 2014. He was brought on the board by Devin Archer, his business partner. Devin Archer was college roommates with Chris Hines, stepson of Secretary of State John Kerry. All three men, Hunter Biden, Devin Archer, and Chris Hines, had all started an investment firm together. Public records show that April 16, 2014, Devin Archer meets with Vice President Biden at the White House. Just 2 days later, on April 18, 2014, is when Hunter Biden quietly joins Burisma, according to public reporting. Remember, this is just 1 month after the United Kingdom Serious Fraud Office opened a money laundering case into Burisma. Hunter Biden joins their board. And not only 10 days after Hunter Biden joins the board, British authorities seize $23 million in British bank accounts connected to the oligarch Zlochevsky, the owner of Burisma. Did Hunter Biden leave the board then? No. The British authorities also announced that it had started a criminal investigation into potential money laundering. Did Hunter Biden leave the board? No. What happened was then, only then, did the company choose to announce that Hunter Biden had joined the board after the assets of Burisma and his oligarch owner, Zlochevsky, were frozen and a criminal investigation had begun. Hunter Biden's decision to join Burisma raised flags almost immediately. One article from May 2014 stated, "The appointment of Joe Biden's son to the board of Ukrainian gas firm Burisma has raised eyebrows the world over." Even an outlet with bias for Democrats pointed out Hunter Biden's activities created a conflict of interest for Joe Biden. The article stated, "The move raises questions about a potential conflict of interest for Joe Biden." Now, even Chris Hines, Hunter Biden's own business partner, had grave concerns. He thought that working with Burisma was unacceptable. This is Chris Hines. He was worried about the corruption, the geopolitical risk, and how bad it would look. So he wisely distances himself from Hunter Biden and Devin Archer's appointments to Burisma. He didn't simply call his stepfather, Secretary of State, and say, "I have a problem with this." He didn't tell his friends, "Hey guys, I'm not getting on the board. I want nothing to do with this." He went so far as to send an email to senior State Department officials about this issue. This is Chris Hines. He wrote, "Apparently, Devin and Hunter have joined the board of Burisma, and a press release went out today. I can't speak to why they decided to, but there is no investment by our firm in their company." What did Hunter Biden do? He stayed on the board. What did Chris Hines do? He subsequently stopped doing business with his college roommate, Devin Archer, and his friend, Hunter Biden. Chris Hines' spokesperson said, "The lack of judgment in this matter was a major catalyst for Mr. Hines ending his business relationship with Mr. Archer and Mr. Biden." Now, the media also noticed. The same day, an ABC News reporter asked Obama White House Press Secretary Jay Carney about it. Here's what happened.
Hunter Biden has now taken a position with the largest oil and gas company, holding company in Ukraine. Is there any concern about at least the appearance of a conflict there? See the vice president.
I would refer you to the vice president's office. I saw those reports. Hunter Biden and other members of the Biden family are obviously private citizens, and where they work is not does not reflect an endorsement by the administration or by the vice president or president. But I would refer you to the vice president's office.
The next day, the Washington Post ran a story about it. It said, "The appointment of the vice president's son to a Ukrainian oil board looks nepotistic at best, nefarious at worst." Again, the appointment of the vice president's son to a Ukrainian oil board looks nepotistic at best, nefarious at worst. And the media didn't stop asking questions here. It kept going. Here's ABC.
You have to fight the cancer of corruption.
But then something strange happened. Just 3 weeks later, a Ukrainian natural gas company, Burisma, accused of corruption, appoints Hunter Biden, seen here in their promotional videos, to their board of directors, paying his firm more than $1 million a year.
Here's more from ABC. Continued on.
And Ukraine wasn't the only country where Hunter Biden's business and his father's diplomacy as vice president intersected. It also happened in China.
This video shows Chinese diplomats greeting Vice President Biden as he arrived in Beijing in December of 2013. Right by his side, his son Hunter. Less than 2 weeks later, Hunter's firm had new business, creating an investment fund in China involving the government-controlled Bank of China. With reports, they hope to raise $1.5 billion.
In fact, every witness who was asked about Hunter Biden's involvement with Burisma, agreed there was a potential appearance of a conflict of interest. Multiple House Democrat witnesses, including those from the Department of State, the National Security Council, and others, unanimously testified there was a potential appearance of a conflict of interest. These were their witnesses. How much money did Hunter Biden get for being on the board? Well, you start looking at this bank records, according to reports, between April 2014 and October 2015, Burisma paid more than $3.1 million to Devin Archer and Hunter Biden. That's over the course of a year and a half. How do we know this? Some of Devin Archer's bank records were disclosed during an unrelated federal criminal case having nothing to do with Hunter Biden. These bank records show 17 months that Burisma wired two payments of $83,333, not just for 1 month, for 2 months, for 3 months, but for 17 months. According to Reuters, sources report that of the two payments of $83,333 each, one was for Hunter Biden and one Devin Archer. Now, Hunter Biden was paid significantly more than board members for major U.S. Fortune 100 companies, such as Goldman Sachs, Comcast, Citigroup. The typical board member of these Fortune 100 companies, we know they're titans of their industry, they're highly qualified, and as such, they're well compensated. Even so, Hunter Biden was paid significantly more. This is how well he was compensated. So Hunter Biden is paid over $83,000 a month, while the average American family of four during that time, each year, made less than $54,000. And that's according to U.S. Census Bureau during that time. And this is what's been reported about his work on the board. The Washington Post said, quote, "What specific duties Hunter Biden carried out for Burisma are not fully known," end quote. The New Yorker reported, quote, "Once or twice a year, he attended Burisma board meetings and energy forums that took place in Europe," end quote. When speaking with ABC News about his qualifications to be on Burisma's board, Hunter Biden didn't point to any of the usual qualifications of a board member. Hunter Biden had no experience in natural gas, no experience in the energy sector, no experience with Ukrainian regulatory affairs. As far as we know, he doesn't speak Ukrainian. So naturally, the media has asked questions about his board membership. Why was Hunter Biden on this board?
If your last name wasn't Biden, do you think you would have been asked to be on the board of Burisma?
I don't know. Probably not.
So let's go back and talk about his time on the board. Remember, he joined Burisma's board April 2014, while the United Kingdom had an open money laundering case against Burisma and its owner, the oligarch Zlochevsky. On August 20th, 2014, 4 months later, the Ukrainian Prosecutor General's office initiates a money laundering investigation into the same oligarch, Zlochevsky. This is one of 15 investigations into Burisma and Zlochevsky, according to a recent public statement made by the current Prosecutor General. On January 16, 2015, prosecutors put Zlochevsky, the owner of Burisma, on whose Hunter Biden sat on his board, on the country's wanted list for fraud, while Hunter Biden's on the board. Then a British court orders Zlochevsky's $23 million in assets be unfrozen. Why was the money unfrozen? Deputy Assistant Secretary Kent testified to it.
Somebody in the General Prosecutor's Office of Ukraine shut the case, issued a letter to his lawyer, and that money went poof.
So essentially paid a bribe to make the case go away.
That is our strong assumption, yes, sir.
He also testified that the Ukrainian Prosecutor General's office's actions led to the unfreezing of the assets. After George Kent's confirmation, that prosecutor was out. Victor Shokin becomes the Prosecutor General. This is the prosecutor that you'll hear about later, the one that Vice President Biden has publicly said he wanted out of office. In addition to flagging questions about previous prosecutors' actions, George Kent also specifically voiced other concerns, this time to the Vice President's office about Hunter Biden. In February 2015, he raised concerns about Hunter Biden to Vice President Biden's office.
In a briefing call with the National Security Staff of the Office of the Vice President in February of 2015, I raised my concern that Hunter Biden's status as a board member could create the perception of a conflict of interests.
But House managers didn't tell you that. This is all while Hunter Biden sat on Burisma's board. Did Hunter Biden stop working for Burisma? No. Did Vice President Biden stop leading the Obama administration's foreign policy efforts in Ukraine? No. In the meantime, Vice President Biden is still at the forefront of the U.S.-Ukraine policy. He pledges $1 billion loan guarantee to Ukraine, contingent on its progress in rooting out corruption. Around the same time of the $1 billion announcement, other people raised the issue of a conflict. As Obama administration's special envoy for energy policy told The New Yorker, it raised Hunter Biden's participation on the board of Burisma. He raised it directly with the vice president himself. This is a special envoy to President Obama. And the media had questions too. December 8, 2015, the New York Times publishes an article that Prosecutor General Shokin was investigating Burisma and its owner, Zlochevsky. The Times report, here's their quote, the credibility of the Vice President's anti-corruption message may have been undermined by the association of his son, Hunter Biden, end quote, with Burisma and its owner, Zlochevsky. And it wasn't just one reporter who asked questions about the line between Burisma and the Obama administration. As we learned recently through reporting on Fox News, on January 19, 2016, there was a meeting between Obama administration officials and Ukrainian prosecutors. Ken Vogel, journalist for the New York Times, asked the State Department about this meeting. He wanted more information about the meeting, quote, where U.S. support for prosecutions of Burisma holdings in the United Kingdom and Ukraine were discussed, end quote. But the story never ran. Around the time of the reported story, January 2016, meeting between the Obama administration and Ukrainian officials took place, according to a Ukrainian press report, as translated, says, quote, the U.S. Department of State made it clear to the Ukrainian authorities that it was linking the $1 billion in loan guarantees to the dismissal of Prosecutor General Victor Shokin, end quote. Now, we all know from the Obama administration and from the words of Vice President Biden himself, he advocated for the Prosecutor General's dismissal. There was ongoing investigation into the oligarch Zlochevsky, the owner of Burisma, at the time. We know this because on February 2nd, 2016, the Ukrainian Prosecutor General obtained a renewal of a court order to seize the Ukrainian oligarch's assets. A Kiev Post article published on February 4th, 2016, says the oligarch Zlochevsky is, quote, suspected of committing a criminal offense of illicit enrichment, end quote. Over the next few weeks, the Vice President had multiple calls with Ukraine's President Poroshenko. Days after the last call, on February 24th, 2016, a D.C. consultant reached out to the State Department to request a meeting to discuss Burisma. We know what she said because the email was released under the Freedom of Information Act. The consultant explicitly invoked Hunter Biden's name as a board member. In an email summarizing the call, the State Department official says that the consultant, quote, noted that 2 high-profile citizens are affiliated with the company, including Hunter Biden as a board member, end quote. She added that the consultant would, quote, like to talk with Undersecretary of State Novelli about getting a better understanding of how the U.S. came to the determination that the country is corrupt, end quote. To be clear, this email documents that the U.S. government had determined Burisma to be corrupt. And the consultant was seeking a meeting with an extremely senior State Department official to discuss the U.S. government's position. Her pitch for the meeting specifically used Hunter Biden's name, and according to the email, the meeting was set for a few days later. And later that month, on March 29, 2016, the Ukrainian parliament finally votes to fire the prosecutor general. This is the prosecutor general investigating the oligarch, owner of Burisma, on whose board Hunter Biden sat. 2 days after the prosecutor general is voted out, Vice President Biden announces that the U.S. will provide $335 million in security assistance to Ukraine. He soon announces that the U.S. will provide $1 billion in loan guarantees to Ukraine. Now let's talk about one of the Democrats' central witnesses, Ambassador Yovanovitch.